We have the assault weapon ban. We have a 10-day waiting period. We have an approved list of handguns that can be sold in the state. We have micro-stamping requirements on handguns, a theoretical firearms tracing technology that's never been proven to actually exist. We have high-capacity magazine bans, universal background checks, and gun violence restraining orders for red flag laws. The list goes on and on. However, none of these laws actually reduce gun violence, mass shooting, suicides, or general criminal behavior. Criminals still get their guns illegally, and regardless of what law California puts in place. In California, the law-abiding gun owner is the one that's negatively affected by these laws. And unfortunately, California is the birthplace for many of these draconian and absurd laws that are now being proposed on the federal level and in your individual states. This is why it's vitally important to not write California off as a lost cause. This is the reason I believe the fight for the Second Amendment depends on our success in California and why we fight so hard to oppose these laws in California. Most recently, I've had the pleasure of stepping into the ring and challenging two of California's feel-good gun restrictions, representing California individuals and FFLs, as well as Second Amendment Foundation, Firearms Policy Coalition, Firearms Policy Foundation, the Cal Gun Rights Foundation, and the San Diego County Gun Owners Association. As these are active cases, I can't go into too much. In 2019, California enacted a ban on the selling and transferring of all types of firearms to young adults ages 18 to 20. According to the state, these young adults who can enter into the military and die for their country, enter into contracts, get married, and be tried as adults in criminal matters, they are too immature and impulsive to be trusted with guns. So the state decided to completely strip them of their fundamental right of self-defense. Our federal court case, Jones v. Becerra, is going to change that. Our Constitution is very clear. A review of firearms restrictions dating back to colonial founding eras are clear. Young adults have the right to defend themselves. They have the right to keep and bear arms, and we're going to prove that in court. I've also had the pleasure of challenging California's assault weapon ban in another federal court challenge, Miller v. Becerra. In this case, I'm working with another fantastic attorney who you're going to hear from today, George Lee. And whether you're up to date on California's many gun restrictions, you're now becoming familiar with the assault weapon laws because the federal assault weapon ban that was that's been proposed was based off of California's law. In California, among the other restrictions of what kind of plastic grip or adjustable stock you can attach onto your gun, if an individual takes their lawfully owned rifle that does not meet the definition of an assault weapon, and they insert their lawfully owned high-capacity magazine into that gun, they've now magically created an assault weapon and have committed at least 2 felonies in California law. Can't have that. Both of these guns and their magazines are arguably the most commonly used firearms in the country and are used for self-defense, sport, recreation, hunting, and any other lawful purpose you can think of. The Supreme Court in Heller was clear. These arms are fully protected under the Second Amendment, and we're going to hold the state of California to that. The Second Amendment litigation efforts are stronger than ever. We're going to do everything we can to restore the Second Amendment to California. Nevertheless, past legal decisions in California, as well as decisions that come out of the Ninth Circuit, have showed us that even when the Constitution and the law is on our side, it is always an uphill battle. Therefore, that's why it's extremely important that all of you continue to do what you do. Continue to be responsible advocates for the Second Amendment. Help replace ignorance with knowledge, introduce reason and spread awareness, and never be complacent because the state that you are in doesn't have those crazy laws like that one on the coast. We have the numbers and support to put the right people into office that defend the Constitution rather than strip it of its meaning. Litigation is truly the last stand when it comes to these laws. We cannot forget the many tools that we have available to us through these organizations, our grassroots efforts, and through our vote. I'm a gun owner in California. I'm fighting for my rights as well as your rights. It's personal, it really is. We're going to do everything we can to restore those rights. Thank you.
If I could ask the gentleman in the back to stop talking, thank you so much. Now, I'd like to welcome Matthew Goldstein. Thank you.
When I was a police officer, we had this saying, front sight, trigger pull. That doesn't have anything to do with what I'm about to talk about, but I was told I had 8 minutes. I just started at 10. I am the chair of the International Trade and National Security Group over at law firm Afari and Metcalf in Arizona. I'm an ITAR guy. And I'm here to talk about the case of Defense Distributed and the Second Amendment Foundation of Tom Williamson versus the United States Department of State. And to talk about the impact of the Department of State's application of the International Traffic in Arms Regulations, the ITAR, on gun-related speech that's protected under the First and Second Amendment. Now, the Department of State implements the ITAR to protect United States national security and foreign policy interests. And the ITAR, as many of you may know, prohibit or restrict the exports of defense articles from the United States. And defense articles, that's items, software, technical data that's described on the ITAR United States Munitions List, the USML. And the USML has 21 categories of defense articles that are subject to control. The very first, category 1 of the USML, is for firearms. And the Department of State knows, or it should know, that it cannot impose the ITAR as a prior restraint on public speech. Since 1978, the United States Department of Justice Office of Legal Counsel has advised the Department of State, the Department of Commerce, the White House, and even Congress that to impose a prior restraint under the ITAR or other export regulations on public speech violates the First Amendment. In 1997, in the wake of the Oklahoma City bombing, the Department of Justice issued a report to Congress about a proposal to impose a strict liability prohibition on the publication of bomb-making information on the internet. And the Department of Justice said, you can't do that. It would violate the First Amendment. So what changed? Well, in December 2012, a company out of Texas named Defense Distributed posted a variety of gun-related information on the internet. This information included CAD, computer-assisted design files, that can be used with a 3D printer to manufacture a high-capacity magazine, an AR-15 lower receiver, and a one-shot gun called the Liberator. What also happened in December 2012? There was the shooting at Sandy Hook Elementary. There was a tragic shooting in which a shooter shot and killed 26 people, 20 of which were children. In response, the Obama administration set forth an announcement of a very ambitious gun control agenda. A primary focus of this agenda was a ban on high-capacity magazines. Now, it's, as you can imagine, difficult to control high-capacity magazines when folks can just print them in the privacy of their home. And so it's within this background that in May 2013, the Department of State sent Defense Distributed a letter warning that it may have violated the ITAR because it did not obtain prior approval from the Department of State before publishing the information on the internet. It warned, it demanded that the company take down the information it posted online, and it instructed Defense Distributed to file what they call commodity jurisdiction requests with the Department of State, basically requesting the agency to determine whether or not the files themselves are indeed subject to ITAR control. Defense Distributed complied with every one of these requests. It took down the information, and it submitted the commodity jurisdiction request, actually 10 requests. After 2 years of waiting, there was no response. And so, Defense Distributed, the Second Amendment Foundation, filed a lawsuit in the Federal District Court for the Western District of Texas against the Department of State the Director of Defense Trade Controls, which is the subordinate agency in the Department of State in charge of implementing the ITAR, and against various government officials. Our Second Amendment claim was based on our argument that the right to possess firearms also includes the right to acquire them, and that the most basic means to acquire a firearm is to make it. We moved for a preliminary injunction. The court denied our preliminary injunction. We appealed to the Fifth Circuit Court of Appeals, and they affirmed the lower court's denial of our preliminary injunction in a 2-to-1 vote. Now, in her dissent, Judge Edith Jones wrote a very lengthy opinion in which she adopted pretty much every one of our First Amendment arguments for why the application of the ITAR to public speech involving firearms violates the First Amendment. We followed a writ of certiorari for the Supreme Court review, which was denied, and the case was remanded back to the Western District of Texas. It's at that time that the court ordered the parties to exchange the Department of State to actually amend the ITAR, to remove the amendment was pending, and a notification of a modification of the ITAR posted online to allow all U.S. persons to share, contribute, and otherwise use and benefit from that information. In short time, Everytown and Brady organizations filed motions to intervene to stop the settlement agreement. On July 27th, 2018, we went down to Texas. The court denied the organization's motion to intervene, and that same day, the Department of State issued the license to Defense Distributed, posted the temporary modification, and Defense Distributed posted lawfully 10 CAD files. They were complete CAD files for AR-15, AR-10, Colt 1911, other guns and guns parts. But within a few days, Washington State, we were able to obtain stays in New Jersey, Washington, District of Columbia. And they're arguing that the Department of State's actions under the settlement agreement violate what we call the Administrative Procedures Act, the APA. They have 2 points they raise here. One is that the Department of State didn't follow proper procedures under the Arms Export Control Act, which is the statutory authority for the ITAR. In that they say that there was a requirement that there be a 30-day advance notification to Congress before they issue this license to basically release the stuff on the internet, which they said is tantamount to a release of controls. I've been working in ITAR for about a little over 15 years now, and I can tell you quite confidently they're wrong. The section they're talking about, Section 38F of the Arms Export Control Act, it doesn't apply to situations like we had. It doesn't apply that the decision by the Department of State was arbitrary and capricious as part of a larger export control reform initiative by the Obama administration. But plus, in a press release by the Department of State, they said the reason why they settled this matter was because the Department of Justice had told them that they were going to lose in court on First Amendment grounds. And that's pretty consistent with all the guidance the Department of Justice has been giving them since 1979. We presented all this information to the court, all the Department of Justice memoranda, even the report I discussed from 1997. The court still issued the injunction. The injunction is twofold. One, it says that the Department of State cannot issue a license and a temporary modification, but that was already issued and the information was published. So the court also held that we need to maintain the status quo, which really was the information was out there, but in the court's view, the status quo is that the parties need to treat the situation as if the license and temporary modification were never issued. And so what that meant was we have basically a takedown order. The Defense Distributor was required once again to take the information down from the internet. And we now have a new type of censorship going on. The status of the case right now is that all the parties have filed cross motions for summary judgment. We're awaiting a decision. And it's a hard fight. It's continuing, but it's worth fighting. Thanks.
Well, good afternoon. My name is David Jensen. McDonald versus Chicago came down in 2010. Organizations I've represented are the Second Amendment Foundation, the National Rifle Association, the Liberal Gun Club, as well as more state and local level organizations throughout Massachusetts, Connecticut, New York, New Jersey, Maryland, and Illinois that I can even attempt to recall standing here. In particular, at the present time, I am counsel on 2 petitions for writs of certiorari that are pending before the Supreme Court that raise the bearing arms issue. That's Gold versus Lipton, Mass State Police, that is currently pending oral argument before the Illinois Supreme Court. We won that case at the trial court level, ruling on constitutionality, and the state attorney general appealed it directly to the state Supreme Court. One lawsuit at a time. And what I'd like to address is simply, where are we at now? And in particular, where are we at on this issue of the right to bear arms? And the answer is, ask me again in 11 days. From where we're at right now, with the state of play in the federal, without some sort of decision from the U.S. Supreme Court that requires a reset of some of the decisions that have been handed down. In the 10 years or the 9.5 years since McDonald was decided, the Supreme Court is largely in the case New York State Rifle and Pistol Association versus City of New York, which, while not squarely a right to bear arms case, concerns the validity of the City of New York that effectively prohibit lawful or most lawful New York City gun owners from transporting their handguns outside of the city, whether to a gun range, a second residence, whatever. So after they granted certiorari in that case, something kind of curious started to happen, which is that when cert petitions came in front of the court, the process at the Supreme Court, when the court is in session, they meet about once a week for what's called a conference session. And at that conference session, 2 of the most pertinent things they do, especially for this discussion, is they consider pending writs or petitions for writs of certiorari, pending cert petitions, and they also consider pending motions before the court. So what started happening is, in both Gold v. Lipton, the Massachusetts case I mentioned, as well as in Rogers v. Gruel, which dear friend of mine, Dan Schmutter, case is sitting there pending, and presumably the angle is that they're going to make some sort of an order after they decided the New York City case. So what else happened? Well, it turns out the City of New York really did not want to go to the U.S. Supreme Court. So the city adopted new rules and regulations, and the legislature changed state law in a manner that may very well result in that case being moot. And then the city came in and filed a motion and said, you should dismiss it. It's moot. And that motion, the court is scheduled to consider at its next scheduled conference date, which is October 1, 10 days from now. Now, what also started happening is, in the Cheeseman versus Polito case I mentioned a few minutes ago, we filed a cert petition on that last summer, and the court took the extraordinary step of requesting a response from the New Jersey officials on the other side of the case before it had gone into conference, and then scheduled it for submission also at that October 1 conference. So, as things stand now, on Wednesday, October 1, they are presumably going to go into chambers. They're going to decide this pending motion to dismiss as moot, and then they are going to take a look at all of these cert petitions. There's at least 4 I know of that have stacked up, raising right to bear arms issues, and they are going to make some sort of a decision about what, if anything, they are going to do with it. So, where are we at? Ask me on October 2. Keep your fingers crossed and check. Thank you.
You guys really aren't being paid by the word. Everybody's gone short so far. Oh, anyway,
You don't want the
Mr.
marker,
Lee.
especially with the cap off.
Wait, I did bring my book with me. I got my alphabet wrong. You're right, Don, sorry. Okay, thank you, my apologies.
Good afternoon, my fellow patriots. My name is George Lee, and I am an attorney at Siler Epstein LLP in San Francisco. Now, I flew in from San Francisco yesterday, so the good news is that apparently San Francisco hasn't enacted a terrorist no-fly list yet. So. Think of my office as your outpost on the frontiers of liberty, surrounded by hostile and angry tribes. It's my great privilege and pleasure to be able to represent organizations like Second Amendment Foundation, Firearms Policy Coalition, CalGuns Foundation, and others in various state and federal litigation that we have going in California. And I would like to talk to you today about 3 cases that we and staff have in California and give you the status of those. The first case I'd like to tell you about is a case called Weeze versus Becerra. And Weeze was the first filed challenge to California's large capacity magazine ban, which we filed in October 2017 after the California legislature enacted a oppressive package and relentless package of gun control measures, which we now not so fondly refer to as Gunmageddon. And the status of our case, Weeze, is currently stayed pending the outcome in a similar case brought by the California Rifle and Pistol Association called Duncan versus Becerra. And I'd like to take a moment, just personally, to point out the excellent work that attorneys Sean Brady and Anna Barbier did in that case to get a favorable ruling from the judge in joining the large capacity magazine ban. So our case, Weeze versus Becerra, is stayed pending the outcome of that case in the Ninth Circuit. But there are some differences that I'll just briefly mention to you. Our case, Weeze, does have additional claims that are not presented in Duncan, including a vagueness claim. Now, without getting too technical into it, because I realize it's late in the afternoon, there are currently 2 different versions of the large capacity magazine ban that are chaptered and split up, that one version of which has exceptions. For example, if you have a firearm for which they never made a magazine that holds 10 rounds or fewer, that could be an exception. The other version, there are no such exceptions. Both are currently live active statutes. Which one's correct? I don't know. I guess we'll let the Ninth Circuit decide that someday. That's going to be irrespective of what happens in Duncan. The other one is a challenge on equal protection grounds to the Hollywood exception, which allows an actor like Matt Damon to rant with anti-gun speeches during the day and take a large capacity magazine home at night simply because he's a Hollywood actor. But if I may just divert for a minute about the legal aspect, I think the lesson of California's large capacity magazine ban is that when they say, we'll grandfather these things in, don't believe them. It's a false promise. Because the fact of the matter is, in 2000, the California legislature banned the importation, sale, manufacture of new large capacity magazines. But they said, I guess to paraphrase Obama, if you like your magazines, you can keep your magazines. But 18 years later, not so much Obama, now it's Darth Vader. We have altered the deal. Pray that we don't alter it further. So the lesson of California's large capacity magazine ban is when they tell you that grandfathering will lessen the sting of these measures, don't believe in their false compromise. The second case I'd like to tell you about today is a case I'm excited about. We just filed it. It's a case called Miller versus Becerra. And this is a case that is currently in front of Judge Benitez, who gave the plaintiffs a favorable ruling in the magazine case. And this is a challenge to California's assault weapons statute, once again. And this one is going to be based on features. Right now, it starts with magazines, which are a feature, of course, but it's going to include all the standard AR-15 features: flash hider, collapsible stock, pistol grip. And I would like to thank the San Diego County gun owners for their ability to mobilize and organize very highly motivated people who can bring these types of claims. The goal in Miller is very simple. It is to restore the command of Heller, which states that governments may not ban by category firearms that are in common use for lawful purposes, such as self-defense, sport, or defense of country. And contrary to what they may say in the sheltered enclaves of San Francisco and Los Angeles, they don't have to drive very far, by the way. AR-15 rifles are indeed commonly owned by Americans of many stripes. And our own California Department of Justice estimated that from 2001 to 2016, there were an estimated 1.5 million legally owned firearms that they classify as assault weapons in California alone. So it is our hope that maybe someday, once again, a case called Miller will stand for the proposition that if it's good enough for militia service, it's good enough for an ordinary citizen. The third case I'd like to tell you about is a very interesting case. It's a case called Linton versus Becerra, and it's an interesting case based on undisputed, straightforward facts. Two gentlemen had nonviolent felony convictions from a long time ago in the states of Arizona and Washington. And those felony convictions have been set aside, vacated, and in fact, the judges of those states expressly ordered that these gentlemen have their Second Amendment rights restored to them. Now, notwithstanding these court orders from Arizona and Washington, the state of California simply refuses to recognize them, including the Second Amendment, the full faith and credit clause of the Constitution, the privileges or immunities clause of the 14th Amendment, and it might seem like small ball, but this is a case that matters. And why does it matter? Well, two things. First, this is actually a situation that occurs more often than you think. Ever since we filed the case, I actually get a number of calls, people saying they're in that same position. They have an out-of-state felony conviction that's been vacated or set aside, and California still denying them the right to own a firearm. But the second reason why this case matters is because what we're trying to do is roll back this mentality that rights are special privileges that the state can grant or deny at whim. The Attorney General in our case, in fact, confirmed this mentality when they said in their motion to dismiss our case, they said, quote, "The complaint's allegations center around two individual plaintiffs who each contend that they deserve this special treatment because an out-of-state court allegedly has set aside their felony convictions." They think that your Second Amendment rights are special treatment. So this is why we fight, and this is why we bring these lawsuits, and this is why we will restore the Second Amendment one lawsuit at a time. What's it like to bring Second Amendment cases in courts in California? Well, I like to think of our situation, without getting too grandiose about it, I like to think of our situation as like that battle off Samar during World War II, which took place in October 1944, where a small group of US destroyers and escort carriers were surprised all of a sudden to find that they were the only force between our landing forces at Leyte Gulf and the Japanese fleet that came out of nowhere with battleships, cruisers, and destroyers. So suddenly find this force bearing down on them. And what did these American destroyer captains do when they were confronted by this overwhelming enemy force? The American destroyer captains laid down smoke and headed straight into the oncoming Japanese fleet. In the words of the late great writer Herman Wouk, who wrote of this battle through the voice of a fictional character, said, quote, "The vision of these three destroyers charging out of the smoke and the rain, straight towards the main batteries of Korea's battleships and cruisers, can endure as a picture of the way Americans fight when they don't have superiority. Our school children should know about this incident, and our enemies should ponder it. In our fight, and against these forces, let us endeavor always to lay down smoke and turn towards the enemy in a manner that our school children will remember and thank us for, and that our enemies will have to ponder. Thank you.
Now that my outfit has been corrected, Mr. Kilmer.
You know, when there's a beautiful woman and there are 7 helpers up here, I couldn't help but think of Snow White and the 7 Dwarfs. When I look at the talent that's up there on this table, I know who's doping. Thank you, gentlemen, your wonderful colleagues. Well, even in California, we're starting to see some victories. Gun shows. 20 years ago, I filed Nordyke versus King to stop Alameda County from banning gun shows at the Alameda County Fairgrounds. It took 13 years to finally win that case and have gun shows in Alameda County. Earlier this year, the Second Amendment Foundation, through my office, teamed up with the California Rifle and Pistol Association to stop the 22nd Agricultural District from imposing a moratorium on gun shows at the San Diego County Fairgrounds. While the government, quote-unquote, studied the issue and imposed a moratorium so that they could take a look at how dangerous gun shows were. Now, mind you, gun sales account for 2% of gun sales in the state of California. And despite the attempt to characterize non-gun show events as attracting violence to the venue, it was actually other events that were causing problems for the police and the public safety people in San Diego County. Anyway, we managed to get a preliminary injunction to set aside the moratorium. In fact, next weekend, Crossroads of the West will host a gun show at that venue. In contrast to Nordyke, which took 13 years to resolve, we filed suit in January this year, and by June we had an injunction. And now we have defendants who want to come to the negotiating table to try and resolve the case without further litigation. Hat tip to Mr. Michel's office and his team of lawyers, including Mr. Brady, Ms. Barbier, and Tiffany. And let me say something a little bit un-PC here. I, for one, am happy that female lawyers are starting to fill the ranks of Second Amendment advocates. They are oftentimes much more talented and reasonable than people like me. Of course, after beating up on the 22nd Agricultural District, the California legislature and Governor Newsom now want to try and pass a state law completely banning gun shows on county properties. So look for this case to go into extra innings, folks. Gun confiscations. I'm currently litigating a case in the Ninth Circuit, Rodriguez versus City of San Jose. We just had to file a petition for en banc review earlier this month after the Ninth Circuit made up, out of whole cloth, an exception to the Fourth Amendment for seizing weapons from the spouse of somebody who is prohibited and refusing to return firearms after she had transferred the weapons to herself, had got the California Department of Justice to release the firearms to her, had proven that she had a state-approved gun show or gun safe, and the City of San Jose still refuses to return the guns. That case also will be going into extra innings. California roster, you've heard some other very fine advocates up here talking about Pena versus Hogan. That's a case that I'm privileged to work with Mr. Gura on. It is currently pending with the United States Supreme Court on a petition for certiorari with that court. It is a challenge to California's handgun roster. You've already heard enough about that, but it is an essential principle that we cannot let the government win these the gun prohibition fight through the death from 1,000 cuts battle, and that's essentially what they are doing. if they can keep advancing inch by inch, cut by cut, we'll all end up one day in California with single-shot 22s. One case that we are currently litigating, and we are just getting ready to enter the discovery phase, is a case called Roe versus the United States. The plaintiffs in this case are all named by pseudonyms because we're dealing here with the intersection of gun rights and mental health issues. In California, we have two procedures for what are called mental health holds. There's a 5150, which is an unadjudicated mental health hold, where if you have a mental health episode and we're not really sure what your diagnosis is, you can be held for 3 days without judicial intervention at all to see whether or not you are a danger to yourself or others. That results in California in the loss of your gun rights for 5 years unless you go back to court to get your rights restored. And oftentimes, and I do a lot of this work in my practice, oftentimes the rights are restored. Oftentimes you shouldn't lose your gun rights because you had a bad day. But California also has a process called 5250, which is an adjudicated hold. Once you've been there is a judge who has said, we're going to hold you for longer than 3 days, oftentimes up to 14 days, then federal consequences kick in. And the federal consequences for an adjudicated mental health hold are for life. Now, this issue was recently litigated at the Sixth Circuit in a case called Tyler versus Hillsdale, and it actually went up to en banc, never got to the US Supreme Court. The government lost that case, where the en banc panel of the Sixth Circuit returned a decision that said, you must have some form of review to restore rights in place. And since the federal government does not have one, the case was sent back to the district court for further litigation. Roe versus United States will be the Ninth Circuit version of that case, so that we can get the issue resolved once and for all. On a personal note, I'll be moving my base of operations to the state of Idaho. Not because the gun situation in California is that bad. The gun situation in California is tolerable. We are winning there, one suit at a time, but it's let's call it pre-retirement planning for me. In any case, of course, California is sitting in other areas other than our gun rights. California is addicted to high taxes, business regulation, poor land management, poor resource management, homeless encampments, and now we see medieval diseases starting to spring up in our urban centers like the plague, typhus, and cholera. So let's remember that in my closing remarks, we'll never forget that the Second Amendment is just one of the bricks in the foundation of a civil society. We must strive to preserve and protect all the rights that were deeded to us by our ancestors. Otherwise, we squander their sacrifice and their wisdom. Thank you.
Next, we'll hear from New Jersey, and finally, we'll hear from Illinois.
One of the lights in my room is not working, so I was wondering how many gun owners it takes to screw in a light bulb. Turns out the answer is 4. 1 to screw in the light bulb, and 3 to argue with each other as to whether the light should have been a Surefire or a string light. My name is Dan Schmutter, I'm an attorney in New Jersey and New York, and I've represented a number of Second Amendment organizations, including Second Amendment Foundation, Firearms Policy Coalition, CalGuns, National Rifle Association, the Association of New Jersey Rifle and Pistol Clubs, Jews for the Preservation of Firearms Ownership, and an organization called Knife Rights that I think many of you are familiar with. Now, as I said, I handle cases in New York and New Jersey. I'd like to start with New York. I want to give an update on the New York City grabbing knife lawsuit that has been sponsored by Knife Rights. I know a lot of you who've come to this conference year after year have heard me talk about that case. It's been going on for many, many years. This was our lawsuit against New York City to stop them from arresting ordinary folks carrying ordinary pocket knives, alleging that these knives were gravity knives. Arrests to the tune of tens of thousands of people. And you may have heard that we achieved a wonderful legislative victory when New York Governor Andrew Cuomo finally repealed the horrific law that resulted in all of these arrests and folks being jailed. But you may not have heard how it came about. Now the key to this story is coalition building and what we might call big tent activism. Now the effort involved 8 years of litigation and years of legislative efforts. And spearheading this all were, of course, Knife Rights Chairman Doug Ritter and Director of Legislative Affairs for Knife Rights Todd Rathner. But what we managed to do was loop in a whole host of disparate participants in the legislative and the litigation effort to achieve what Todd has described as, quote, probably the only pro-Second Amendment law ever to be passed in New York. We had Democrats and Republicans, we had the New York Legal Aid Society, NAACP, ACLU, the Cato Institute, the NRA, unions, the New York Times, and all sorts of other people, all involved in that effort, either in the legislative side, the litigation side, and sometimes both. And, you know, to show how such, this kind of cooperation can work, for 3 years, the New York legislature overwhelmingly passed a repeal of the gravity knife law, and twice the governor vetoed it. But you need to persist. And this year, the bill was passed again overwhelmingly by the legislature. In fact, the bill was unanimous. And there was also another convenient time lawsuit events. And I'm pleased to say that the bill's sponsor credited our 8 years of relentless litigation as being one of the material factors in getting the governor to finally sign that bill repealing the gravity knife prohibition. So we're very pleased with that, and it really does show that when you have a lot of different people cooperating, and when you think about this struggle and this effort as the type of thing that can involve all sorts of different people from different organizations, different groups, and different walks of life, you can really achieve extraordinary things, especially in a place like New York. I want to talk about another case. A number of people have already talked about the case before the United States Supreme Court, New York State Rifle and Pistol Association versus New York City. Dave Coppola spoke at length about it. I know Dave Jensen spoke about it as well. You've heard that several of us have cert petitions that are now sitting at the court awaiting to see what the court's going to do with the New York City case. Don has the Pena case, Dave Jensen has the Google case. And I want to talk a little bit about one of the cases that I have, which is Rogers versus Grail. Now this is a challenge to New Jersey's highly restrictive carry law. As you may know, there are still a few jurisdictions where carry is very, very highly restricted. New Jersey is one. So this is a challenge. You may remember a few years ago the Drake decision from the United States Court of Appeals for the Third Circuit, where the Second Foundation challenged the New Jersey law back then, and unfortunately the result went against us. This time we decided to bring the case again in light of the very, very positive decision in the United States. So you can sue a car dealer for selling a car and not informing them that it's illegal to exceed the speed limit. So we're pushing back on this lawsuit. We're hoping to defeat this new legal theory in its infancy to prevent it from spreading around the country. Thank you.
Hot dog, I got 9 extra minutes. All right, you guys have been listening to lawyers for an hour, and appreciate how you guys are all holding up so far. I'm going to ask you to hold on just a little bit longer. I'm pretty sure the next panel is non-lawyers. Is that right? So you have that to look forward to. My name is David Siegel. I am a practitioner in Glen Ellen, Illinois, just outside of Chicago, and I represent the Second Amendment Foundation on a number of matters, and I'm also counsel for the Illinois State Rifle Association. Shout out to the guys over there. And Illinois Carry is also out that way, and I represent them, and quite frankly, without those groups, there's no way that I could be doing what I'm doing. So thank you all these groups for their help, and especially for staff for giving this platform to talk to you today. There's a number of things going on in Illinois and really across the United States that I wanted to talk to you about today. Try to give you the abbreviated versions though. There are three cases, Miller versus Walker, Johnson versus Lyon, Attaway versus Coursey. Those cases are in Illinois and Michigan and Missouri respectively. They all have they all concern the issue of Second Amendment rights for foster parents. The states all have rules that if you are a foster parent in that state, you must abide by certain regulations, which generally include disarming yourself. They all put in force, what the governments like to call safe storage requirements, where you have to have your firearm and your ammunition in separate locations and separate safes, and that does you pretty much no good if someone happens to break in at 2 a.m. Also, if you are licensed to carry, you're not allowed to carry on your person in the home, and if you happen to have a carry permit outside the home, well, too bad, you're not allowed to do that either. The Miller case in Illinois also challenges similar restrictions for home daycare providers. Now, let's be very clear about all of these cases. These cases are not about acting stupid and leaving guns in the toy box or anything like that. It is about carrying them, storing them responsibly, but also storing them, being able to carry or store them in such a fashion that if you actually need them, you'd be able to use them. So, for example, in those cases, the plaintiffs are not challenging, say, when you're not using the firearm, lock it up in a safe, but they want to be able to lock it up loaded, so that at 2 a.m., if they need to open the safe, they have it ready for them. The Illinois case is in the discovery period, so is the Michigan case. The Missouri case is kind of in a forced settlement type of stage. The court wanted to see if it could be worked out, and so we're trying to, and we'll see what happens with that. Missouri, of course, has a constitutional carry state, and they recently added to their constitution a strict scrutiny standard that for Second Amendment rights, and we're hoping that action will spur the government to come to see reason on this case. So that's what's going on there. A number of people have talked about housing authority cases. We filed, SAF, ISRA, what we filed is Doe versus East St. Louis Housing Authority. This was a case where we had to file it under a pseudonym because the housing authority resident had a violent ex-paramour recently out of prison who threatened to kill her if he ever found her. In the meantime, she's living in a housing authority where if she has a firearm in her home for self-defense, she can get kicked out. At the same time, she had been attacked and sexually assaulted in her own house, and the only thing that saved her was her kid getting the gun out of the safe. So, which scared the guy off. The housing authority saw reason on that one. They were able to agree to an injunction, and that case has been won. And this is real nice. It's nice to have, a pat on the back and attaboy, but when you do this job, When you have a client crying in happiness on the other side of the phone, when you tell her that the authority, the government, whatever's got the boot on her neck is no longer going to be able to do so, that's why I do this. There's a couple cases, one's that you also heard a reference to it earlier. One is called Cole versus Norwich, Illinois. One is called Second Amendment Harms versus City of Chicago. Both of them are challenges to gun store bans. Both of them were pending for a very long time, and it took all that time to basically get the village, get the city to change their restrictions, change their regulations. They kept doing it incrementally, as government often does. They would say, okay, well, we're not going to ban it anymore, but you can only have it here. Okay, well, you can't just have it here, you can have it in other places, but you got to do this, and so on and so forth. So the Norwich case was recently resolved after the village finally loosened its restrictions enough. In the City of Chicago case, they had to repeal their gun store ban, and now that case is still in its pending stages on damages. The Wilson case, Wilson versus Cook County, is the assault weapon case. There is a cert petition. We lost at the 7th Circuit. There's a cert petition due towards the end of November. We were trying to weave the case around the 2015 Friedman case in the 7th Circuit, which basically upheld a ban on assault weapons. We said this one is different. Cook County as a whole is different from Highland Park, Illinois. You have to allow us to take that into consideration. The 7th Circuit said, no, we don't. We really don't see a difference. And they dismissed our complaint and upheld the dismissal of our complaint. And now we are, like I said, heading for a cert petition on that. Case of Culp versus Madigan, now Culp versus Raoul. The state has a ban, a virtual ban on almost every non-Illinois resident from actually applying for a concealed carry license. The courts unfortunately have upheld that regulation, that restriction. They've said, well, we don't know we don't know if we can trust the people. We have no way of knowing. And we've said, well, you don't know if you can trust Illinois residents either, and yet you give concealed carry licenses to those people that go through the training and are qualified. You should do the same for other people in other states as well. The cert petition will be coming in a couple weeks for that one. Also on the vein of assault weapons is the Easterday versus Village of Deerfield case. This is a case where Village, after the state changed its gun laws in 2013, changed its licensing laws and whatnot, and said, we're taking over, we are preempting this field of assault weapons. If you want to get in and do something different, you have right now to do it. Deerfield said, okay, we'll have a bunch of restrictions, storage requirements and whatnot. 5 years later, they say, that's not good enough, we're going to ban them. We sued them saying, well, state preemption controls that. The court has agreed with us, and they entered a permanent injunction. But the court recently made a ruling that's going to allow Deerfield to appeal that to the Illinois Appellate Court, so we'll be seeing how that goes. I'm actually surprised I haven't gotten that notice of appeal yet, but I'm sure it's coming. Lastly is a couple cases regarding Illinois is one of 3 states that requires you to have a firearm license just to possess a firearm. Massachusetts, I think, is the second, and New York requires one for handguns. If you just want to possess one in your home. A woman in downstate Illinois, her ex-husband or her some status of husband called the police on her, said she's firing a gun in the house. Cops showed up, and no, she wasn't. But the cops did find the 22, the rifle that she had, by the bolt action by her bed for protection, and charged her with not having a firearm license, a firearm owner ID card, a FOID card. The judge struck the license requirement down as unconstitutional for requiring someone just who's law-abiding to just have a long gun by their bed or for in their home for self-defense. Judge said it's unconstitutional to require you to have a license. The state appealed that to the Illinois Supreme Court. Those arguments were 10 days ago, and we'll see how that turns out. You know, I would hope that the argument that this is something that in the day of the framers, people were required to do, and in fact, in one instance, the state even paid for a firearm if you didn't have one, to have one for protection. So hopefully the court will see, and I made it the point, be clear, it's not about handguns, it's not about buying guns, selling guns, anything like that, but if you want, like in colonial days, a long gun for protection, you should be able to have it. In closing, in addition to this, the state likes to take gun rights away and they don't like to give them back. People appeal, they say I should have my rights back, they don't get them. And sometimes they force us to go to court. Sometimes the denials are ridiculous. We'll be filing suits very soon to overturn what is really just a broken system of restoring FOID rights, returning concealed carry rights. We're doing this on an individual basis. We're going to be having a vehicle very soon to try and make this a bigger issue to help all the people of Illinois. And I guess I'll update you all on that next year. So thank you very much.
Okay, I have two surprises. One, we have lost one of our screens, so we're going to take a 5-minute break. Don't anybody move. Okay? Nobody move. And the second surprise is for the attorneys up here. This is not being filmed, so you all are safe. All right? The table mics are live. Okay? They're live. I have 3 questions here, and I can't decide which one to ask you each. So I think I will ask the 3 different questions and just go down. You're going to get whatever question you get. All right? Don Kilmer. All right. What do you think is the most important Second Amendment case that needs to be brought?
Okay, that needs to be brought. Well, it needs to be brought. We should have brought it already, I guess.
Okay.
No, I think the most pressing issue that we're dealing with today is going to be dealing with these so-called red flag laws. Because we're going to be dealing with, California's had these for going on 15 years now. The Rodriguez versus San Jose case, although it was a mental health case, is very much a red flag case. Because this is an instance where the police seized a personal firearm from a wife who she'd done nothing wrong. This gun was registered to her. The police knew it was registered to her. She objected to the gun being taken. They took it anyway. So this idea that the government can come in and disarm not just you if you're having a mental health crisis or you committed a crime, but also disarm your family members, this is going to be a very dangerous area to tread on. And so we're going to need to gear up for dealing with these red flag laws.
Okay, we're going to have to limit it to about 60 seconds, which means you'll take about 75. Matthew, besides Heller, what is the most important 2A case to date? Either pro-2A or anti-2A?
So new kid on the block, I'm going to pass on that one.
Okay, all right, then why did you go into 2A law? Why did you go into 2A law?
Why did they go into 2A law?
Yeah.
Okay, sorry. 2A law to me is kind of a part and parcel of what I do in the trade law. I work day to day with a government agency, Department of State, which is very, very, it has plenary foreign affairs powers, but very much does not care about domestic rights. And the area that is impacted on the most is the Second Amendment.
Thank you. I only get to, I'm appointed for today, so I only get to ask the questions. Okay, Mr. Lee, besides Heller, what is the most important two-way case to date, pro or anti?
I think City of Highland Park is a significant, which is a Seventh Circuit case that did not go our way, is a significant case because it allows, among other things, weapons to be banned categorically in complete violation of the commandment of Heller, because certain weapons make people feel uncomfortable, because they engender scary feelings, which is part of the ruling. Wasn't the complete ruling, but part of the ruling. So I would say that that loss, although it didn't go our way, and the fact that it seems to ignore Heller blatantly is a case that needs to be revisited at some point.
Okay. Mr. Dillon, what do you think is the most important Second Amendment case that needs to be brought, besides red flag laws, which we don't have a case for yet?
Well, red flag laws was going to be my answer. Like Don, I also have fought against these. I think they truly are some of the most dangerous laws and restrictions that are being implemented against, I think, law-abiding citizens. Outside of that, I'm a big fan of bringing everyone we can, to be honest. If we can think it up, let's do it.
Okay, sounds good to me. David? Oh, sorry. My farthest right, David. How did you get into 2A law?
Unfortunately, I'll try to make this a 60-second answer. I had just opened my practice. I got a call from my friend Alan Gura, who said that the Supreme Court had just granted certiorari, agreed to hear the Heller case. Said he knew some people that if they actually win that case, they might win. They wanted to go after Chicago. Did I want to be in? And he said to me, you know, don't answer right away. He said, could be controversial, people picketing outside your door, that kind of thing. You know, think about whether it's something you really want to be a part of. And in that time, like right before he asked me, there were about 2 or 3 stories in the previous month in the Chicago papers. Women who, you know, were found dead with 911 on the phone in one hand and a useless restraining order in the other. And I called Alan back and I said, you know, if I can do something to help those people or the next people, how do I say no to that? So I guess the rest is literally history.
The other day, you know, I have 3 Allens in my life, so I call them Alan, the other Alan, and the other Alan. So you just need the other David. What do you think is the most important 2A case that needs to be brought?
I'll assume it's aside from red flag laws, and I would agree that the red flag law issue is going to be significant, particularly exactly how those laws are set up, where the burdens are, and what the rights of review are. Aside from that, I think I would have to say the standards that govern the denial or revocation of firearms licenses, and that has a close relationship to the ability to obtain relief from firearms disabilities, which has a close relationship to what is a valid firearms disability, and are there some things like, say, misdemeanor convictions that might be valid disabilities for some period of time, but not for the rest of your life.
Okay. Okay, Dan. Besides Heller, what is the most important 2A case to date? Since we've had an ante, how about Pro?
The good news is I get to go last, which means I've had a chance to think about all everybody else's answer. I'm going to answer this on the basis of a case that I think has provided a lot of good citations and has given us a lot to work with. I think it's the Ezell case at the Seventh Circuit, which is a Second Amendment Foundation case, and it has been up and down to the Seventh Circuit several times, and we've gotten a lot of good stuff out of it. You know, what's really nice about Ezell is it gives us very good law on rights that emanate from the Second Amendment and from the right to keep and bear arms, acquiring training, acquiring firearms, gun stores, ranges, who can participate in those kinds of things. It's really a very important step removed from the core Second Amendment right to keep and bear arms. It's things related to the right to keep and bear arms, and the very positive result that we've seen in those several Ezell decisions, I think are very, very valuable.
Yeah, there were several. We called it Ezell 1 and Ezell 2. It was sort of like the never-ending story. Rhonda is here, who was the lead plaintiff. I was intimately involved. I don't think that the attorney in Chicago liked me any better than I liked him. I'm waiting to see if this goes back up, but I'd like to thank you gentlemen very much. This has been an informative panel, and I've had fun with the end. I hope you did too. Do we have the video up? Okay, so we're gonna run just a couple of minutes behind, but if you'd like to come up, Laura and Jeff. Just a small video. There's just a small technical glitch. I believe there are still the yellow and blue bands out front. I'm gonna put yours up so everybody can see it. Okay. Hopefully we'll have the video up in a second, because this is a very important topic, and I want us to have the video of it. So, unless you'd like me to ask you some questions. Okay, Jeff. You're a principal at a school. Superintendent student, excuse me. How does your district feel about this?
Well, that's part of my talk.
Oh, sorry, then I'll ask something different. You bet, okay. You and your wife have 7 children.
Yes, we do.
Okay, at what age do you train them, expose them to firearms?
At any age, really, that they know right from wrong. And my children know we have firearms. I don't hide that fact one bit. I'm an avid hunter. I'm a shooter. And, you know, I have taken them out back and put a jug of water and shoot the jug of water and it explodes. That's what guns do. Until you're ready, until I'm ready to train you, we know not to touch those. We go over the safety of those firearms. But then I've taken my children out because they like to hunt and they know that dad's interests too. And part of the 7 kids that we have, we just adopted and got legal custody of 2 students this past year, so that made us 7.
Wow, that's a lot. Congratulations. And now, you are lucky because you're not going to get a question because now they've got the video working. I thought you might be. So, Jeff and Laura are talking about reversing school disarmament.
My name is Jeff Staggs. I'm a superintendent in Cumberstown Exempted Village School District in the great state of Ohio. Ohio! This is my 16th year being a school superintendent in Cumberstown, but the fact I'm most proud of, we'll be starting our 8th year of having an armed staff at New Cumberstown. You might ask, how did you begin to have an armed staff at your school? Well, after the Sandy Hook tragedy, I actually had moms come up to me and family members of people in the community and say, Jeff, we know by Ohio law that the board can authorize people who have a concealed carry license to carry a firearm in school, and we want that here. It's okay. Put them in front of the Board of Education, and that started our journey. At the same time, it started our journey with Buckeye Firearms Foundation and the Faster Saves Lives program. Today, I'm here to represent Buckeye Firearms Foundation and the Faster program. To date, we have trained over 3,000 educators in 250 school districts across 18 states. We've taught classes in Ohio, Indiana, Colorado, and this past summer in Utah. What does FASTER stand for? Faculty, Administrators, Safety Training, and Emergency Response. The author of the program, of the training, is John Benner of Tactical Defense Institute. He's the owner and operator, a former retired police officer, a military vet, who taught this program all across the country to the National Association of School Resource Officers. So when you hear the agents say, oh, they need to leave that to the experts, or, oh, these teachers, the training, that's not good enough training. We have the exact same training that the school resource officers have that are in schools currently. And then most of the time, our qualification is much higher. But I really want to talk to you today of how FASTER has changed the culture of my school district. I would say before FASTER, I had a fantastic relationship with law enforcement. Our local PD, our sheriff, with their blessing, we sent people to the very first FASTER training. They came back and presented. We presented the training, the qualifications, and they were 100% on board. So much that our sheriff has opened up his department to us. We train right beside him. We qualify with him every year. And they attended a 3-day FASTER Level 3 class, a 2-day, I'm sorry, FASTER Level 3 class at our school, which is 16 hours of force-on-force training. So we were shoulder to shoulder with law enforcement, 16 hours doing force-on-force training. Our sheriff has said if there's ever a critical incident in the Cumberstown schools, and it's still going on when they get there, they're not asking us to stand down. They're asking us to go with, because we now have a brotherhood. A couple years ago, I received pictures on my phone. It was from the sheriff department, and they said, can you share these? Share them as you see fit, but we would like to know if you can find out who this person is. We had a murder outside our small village, and there were pictures of the suspect. 20 minutes later, we gave him the name. We told him where on the social media page he was wearing the same shirt. It's just that kind of relationship that we have. I never dreamed it would have happened. The other cultural change, we had a critical incident where I had to lock down the schools, disperse our armed staff into 4 buildings. Now, it wasn't a school shooting, but it was a very serious situation. I'm in the hallway of the elementary school. The elementary teacher comes up to me, shaking, almost crying, trembling, because it was a very serious event. She asked, Jeff, do we have that program yet? You know that program we have, do we still have that? Yeah, we do. You're safe, your kids are safe. And just the stress that relieved from her body, she stood taller and went back to her kids. I knew from that second we were doing the right thing. I went to a middle school social studies classroom. And the topic of that day was the history of school violence. The kids were going back and forth, back and forth. The young man stands up and said, that's why I love going to this school. These teachers here love me, administrators love me because they have an armed staff here. So do the children know we have an armed staff? Yes, they do. They don't know who it is, but we're very open about that. You can't go into a door in our district without a sign saying armed staff are present. So we don't make any bones about it. You're not going to be famous in our district. We're going to take care of business, and that's our promise. We believe that the faster you can go to an event and stop it, the faster you give medical treatment to the students, the more children are going to live. And how many it's a right for every child to go to school and be safe? I would say to you, run for the school board. That's how you change this. That's how you bring these programs in. Run for the school board. And that's it. We would love to bring this program to your state, to your school, so your children, your school staff, your parents have that same safety as our faster schools. Thank you. It's my honor to be here.
Hi there, my name is Laura Carno, and I run Faster Colorado. In Colorado, we were the first state to fully take Faster Saves Lives from Ohio. A group of folks from Ohio came out in 2017. We are now, I would like to say, completing our third training season, but we actually had to add a Thanksgiving week class just due to demand in Colorado. I'm also a visiting fellow with the Independent Women's Forum. They approached me in January and asked me to come on board to do blogging, op-eds, and media for be able to talk about gun rights. So IWF.org if you want to take a look at the great work that they do there. So I'm going to talk briefly about what is new in the discussions about school massacres, because the language keeps changing. So three things I'm going to talk about briefly. One is understanding motives. It's not what you think. The second is talking about school resource officers versus armed staff. And three, what are the new frontiers? So first of all, will understanding the motive of the killer, of the school killer, you can extend this to other non-school massacres as well, will that stop them? And I did a whole bunch of research on this that was pretty fascinating. Wrote an article called Understanding Motives Will Not Stop Mass Killings. And here's why. The FBI in 2018 wrote a report that said, actually it's not the motive that matters, it's the pre-killing signs. And somebody earlier talked about the Secret Service report. There are some very similar findings. It's the pre-attack behaviors that are far more significant and predictive than actual motive. And when you think about the Parkland killer, it doesn't matter what his motive was. You can call it whatever you want. The pre-attack behaviors were very consistent. Something like 30-some times in 7 years, police went out to his house. So there's a whole lot behind that. But you also have to think about like the El Paso killer, and that wasn't a school, but he had a motive. He claimed a motive of white supremacy. So what happens after that is then people say, well, we have to go after white supremacists. Well, that's actually, as horrifying as white supremacy is, that's actually not the problem. The background is that there's been a bunch of research done called ACEs, Adverse Childhood Experiences. There's a great website called ACEs Too High. It talks about, it takes all of these mass killers and says what's consistent about them. It's not their motive. It's all of these pre-attack behaviors and different things that happen to them in their childhood. So if schools want to do something about changing this behavior, take a look at these kids with high ACEs scores. They've experienced abuse in the home, watched their mother be abused, those kinds of things, and figure out some remediation for those kids if you really want to do something to stop it. As Esther said earlier, get Andrew Pollack's book, Why Meadow Died. That talks a lot about what goes on in these schools, and as a parent and grandparent, think about it this way. Stagg said, run for school board, absolutely. If you're not that person, this is your kid, your grandkid. You are hiring a school, so to speak, hiring a school to educate your kid. You expect your kids to be returned alive every day, so have those conversations with your school. Second, school resource officers versus armed staff. We hear over and over, we'd rather have school resource officers. Okay, and by the way, we're for all of the above. We like school resource officers and armed staff. Set that aside for a second. School resource officers are fully sworn police or sheriff's deputies in your school. And that's great. They can deal with a whole lot of different things. But if there is going to be an active killer, there have been active killers in schools with school resource officers, they know who that person is, and they are likely going to start their crime as far away as possible from that school resource officer. Even if you have SROs, parents and grandparents, do not let your school board or superintendent say it's all good because we have SROs. We still need, call it undercover, concealed carry armed staff on campus. And don't forget that John Lott's new research shows that no school with armed staff, and this is concealed carry armed staff, has ever had a school shooting. Last is the near frontier of armed staff, and that's churches and homeschoolers. Churches have schools. Schools have churches. They're very intermingled now. Church violence, there's now more church violence than school violence, even though we hear about schools more. We see a lot of crossover. There's probably lots of folks in this room who are on their church's armed security team. Check out an organization called FBSN, Faith-Based Security Network, FBSNamerica.com. They do for churches what Faster is doing for schools. But homeschoolers not only, by the way, a fierce group of moms and general moms, a fierce group of defenders. They're not only teaching their kids in school, but once a week they go to these co-ops. And guess what? There's a couple of hundred kids in some kind of a room, not a traditional schoolroom sometimes, who are equally vulnerable. So think about that even for homeschooling. So your call to action, know what's going on in your church, know what's going on in your school, and I'm not getting paid to say this, but get Andrew Pollack's book, and as Esther said earlier, buy one for everyone, because parents and grandparents need to know what's going on in their schools, and it's really scary. The people who could turn into school killers need to be stopped. So thank you very much for having me again.
And our next remarks. My notebook is my brain today. The next remarks are by Edwin Walker from U.S. Law Shield. The Giant Awakens, the outrageous enforcement of existing gun laws. And before Mr. Walker comes to the podium, the Second Amendment Foundation would like to thank U.S. Law Shield for their extremely generous contribution, which helped feed you last night. So you can thank them for the delicious
Howdy, how y'all doing this afternoon? Glad to see we got such a full crowd still here at 4:45 in the afternoon. It's good to see everybody. So you're going to hear from another lawyer. You probably heard from enough lawyers today. I think they stacked all the lawyers towards the end of the presentation today. So I'm just here to add to that. Now, as opposed to the lawyers that spoke to you earlier, my field is a little bit different in that I am one of the primary program attorneys for U.S. Law Shield, started off as Texas Law Shield. Our firm specifically handles most of the emergency calls that come in We handle a lot of the cases involving members. And so whereas the lawyers, the very fine lawyers you heard earlier who litigate against the government, basically they attack the government, they sue the government, which is a fantastic job. They do a lot of appellate work. What we do is we focus on defending people from the government. That's what we do. And we see how the government has overreached in many ways, and how the government arbitrarily enforces its laws. Because, you know, I know if you listen to the anti-gun folks, whenever they talk, they make it seem like there are no gun laws whatsoever, that we live in a world where we are starting at ground zero, there are no gun laws. Oh my God, all we want are common sense gun laws. Failing to realize, of course, that there are hundreds and thousands of laws on the books already at the state, federal, and local level. And these laws, of course, are being enforced every single day by the police and by the prosecutors across the country. Now, this of course, entails a lot of unjust prosecutions, a lot of unjust arrests. You know, the police are out there, their main ability, the main tool that they have is the ability to arrest. Prosecutors, the main tool that they have is the ability to convict. Now, of course, whenever you have only, you know, one tool and your hammer, everything begins to look like a nail. And so this is the way we see a lot of these laws being enforced. Now, as the primary program of lawyers for U.S. Law Shield and Texas Law Shield, we represent, we advise many of our members on these types of situations. Just to give you an example, the title of my talk is The Outrageous Enforcement of Gun Laws. And I did have a PowerPoint. I don't know if it's being shown up on the screen or not. We have taken calls for such incidences as we had a member who was involved in a car wreck, simple car wreck, wasn't even accused of being at fault in the car wreck. However, the police confiscated his gun that was in the vehicle, and it took us over 9 months and a court order to get that gun returned to him, because the police decided that they needed to keep it to run tests on it, to see, of course, if it had ever been used in a crime, which it hadn't, because it had been owned by him, basically, since it was purchased from the retailer. But yet they use this as a common excuse to keep people separated from their firearms. Additionally, we have advised many members whenever they have been scolded, taken to task, and even harassed by law enforcement officers for exercising their right to possess a gun. This especially is true with regard to individuals who have a license to carry a handgun. Now, in the state of Texas, where we are based, up until just a few years ago, your handgun carried by a license holder had to be concealed, but they changed that law to allow a license holder to carry a visible handgun as long as it's carried in a belt or shoulder holster. Now, this has been the law since January 1st, 2016. But yet, even as recently as 2 weeks ago, we had a member who was harassed by a police officer who was telling him that since his old license said concealed handgun license, that he had not yet received his new license that said license to carry on it, that this still meant that he was restricted to concealed carrying only, and that he was not allowed to carry openly because his license still said concealed on it. Now, this is an officer who has been sworn to uphold the law, and yet he does not know the law. We've also had to deal with prosecutors. In one particularly outrageous example, we had a prosecutor who basically, our member was the victim of a crime. A gun was stolen out of his car. He was the victim of the crime. The individual who stole it out of his car was caught, was prosecuted, was convicted of this crime, and yet the prosecutor refused to agree to an order that would have returned the stolen property, the gun, back to its rightful owner. And of course, his statement in justifying this was, well, I'm just not going to allow another gun to be put out on the streets. as if returning it to its rightful owner was somehow contributing to the crime itself. Fortunately, the judge, of course, did not agree with that and immediately signed the order returning the gun. Also recently, in a particularly strange set of facts that we had, there was an individual who got his hand caught in a piece of machinery on his own property. And this piece of machinery basically had taken his hand, had captured him into the machine, where he suffered a very egregious injury to his hand. He could not extract his hand from the machine and started yelling for help, as any of us would. Nobody was responding to his cries for help, perhaps because his voice did not carry very far. Well, he thought to himself, what does carry very far, what will get people's attention, is of course a gunshot. And so he had his gun with him. He fired 2 shots into the ground beside him. Of course, that did get people's attention. They came running. He was rescued from the machine. The police, of course, also responded. He was taken to the hospital where he was mended to return home, only to find out that a warrant had been issued for his arrest for disorderly conduct because he had discharged his firearm in public. So we see a lot of arbitrary and capricious enforcement of these laws. On the administrative side, the Texas DPS, the individuals of the agency that is responsible for evaluating and administering these licenses to carry, which of course Texas is a shall issue state, a very proud shall issue state, which, as many of you know, you meet the qualifications, you get the license, there is no discretion, you cannot prevent it. However, the DPS, since the day that the concealed handgun license was born, way back in 1995, has fought vigorously to limit or try to keep people from getting their licenses to carry. And now we're seeing a very interesting twist in the law in that, or in the way that these applications are being evaluated, in that the DPS now is somehow considering every single misdemeanor assault. So if somebody applies and they have a misdemeanor assault conviction on their record, the DPS has taken the position that that is presumptively an assault for family violence. Because an assault for family violence under federal law means that you cannot possess a firearm. If you cannot possess a firearm under federal law, you're disqualified from getting a license to carry under Texas law. And so the DPS position has taken the position that if you have an assault in your background for a misdemeanor, even a Class C misdemeanor, an assault for which you could not have even gone to jail for, they are taking the position that they are considering it to be an assault family violence unless you prove to them that it is not. And of course that is a ridiculous position to take, but that's what happens when you give the government power. Now in my PowerPoint that I had, but I guess it's not coming up, I had some illustrations of crimes that have been, people who have been arrested in other states where we have seen laws that exist that people have mentioned earlier, red flag laws, magazine capacity bans, assault weapons bans, and I had several of those in my PowerPoint that I was going to show you. Some of you may have heard about, some of them were actually mentioned here today. There was a New York man who was arrested and charged for after he had killed 2 burglars that were burglarizing his house. This happened in the town of Deerfield in New York. He was not charged for killing the people, the burglars who had entered his house, but he was charged for possessing an unregistered firearm. That firearm turned out to be a gun that his father had left him, so he had inherited the firearm. He had no idea that he was supposed to have registered it. It made news, it's on the internet, you can look it up. Fortunately, those charges were dropped against him. However, that New York law is still on the books. It is still lawful to be prosecuted under it. And now that this guy has been arrested but let go, is the next person who is arrested for such in such a ridiculous circumstance, are they going to be afforded the same courtesy? Of course, one would hope, but we all know probably not. Especially now that the prosecutors can say, look, you should have known about it, we had this case earlier, it made headlines, that should have made you aware that you need to be registered, or you need to register all of your firearms, regardless of how you acquire them. The next case, of course, showing the outrageous enforcement of laws would have been the law that, the situation that, Mr. Schilling, former Major League pitcher Kurt Schilling alluded to earlier, the case of Gary Wills, where he was sort of the first victim. Hopefully we don't see other victims, however, experience tells us we probably will. He was the first victim of Maryland's red flag law. Somebody turned him in, said he needed to be the subject of a red flag protection order. The police decided that it was a brilliant idea to go knock on his door at 5 a.m. to claim that they were there to confiscate his firearms. He, we don't know the exact circumstance, but I can imagine it was a state of confusion, answered the door with his firearm in his hand. Then the police, in their narrative, say that he struggled with them, and so they shot and killed him. And then, just a few months later, Maryland basically released the figures stating that in the first 3 months of their red flag laws, that they had seized firearms from 148 people under their red flag law, of course, citing it as we have saved lives by doing this. I hope that they've learned how to enforce these or to issue these protective orders, serve these protective orders, but I'm sure that there has been a lack of due process. Fortunately, nobody else has been killed in the state of Maryland about it. Then I have another story with regard to a man in Connecticut who was investigated under Connecticut's red flag law because he had posted online that he had liked certain memes that involved mass shootings. And they thought that this made him dangerous, even though he had no criminal background and never committed a crime before, but that they went in and searched his internet history, found out that he had liked certain memes about school shootings. Also found out that he had attempted to buy high-capacity magazines over the internet. This, of course, gave the police then probable cause to go in, search him, search his possessions. They found that he was in possession of 2 high-capacity magazines, and so they have decided to prosecute him for that. And in fact, whenever his attorney went to go get a bond, I believe the bond was at some outrageous amount. Can't find it now. For possessing 2 high-capacity magazines, I believe it was something like, $250,000 bond for the possession of 2 high-capacity magazines. And then, of course, there was the story that made headlines a couple of months ago about the Colorado teen who was not allowed to return to school because he had posted pictures of him and his family going out to the gun range and shooting guns. They said that they were investigating him for a threat. Fortunately, school officials did come to the conclusion that there is nothing wrong with going to a range, but yet it illustrated a Colorado law or Colorado policy called Safe to Tell, which, interestingly enough, in the common vernacular now in Colorado is called Safe to SWAT. It is being used by teens. What started off as a school program designed to get teens to make authorities aware of teens that they believe may be the next school shooter has now turned into, of course, a situation where teens are turning each other in as practical jokes or as a way to get revenge against other teens that they do not like. And of course, the last story that we had was a California man who was arrested for possession of 1,000 guns. Of course, they said, oh my God, who should have 1,000 guns? Nobody should have 1,000 guns. He was outed. They said somebody went to the police and said, this man has got too many guns. You should go in and investigate him. Out of the 1,000 guns, they are now prosecuting him for, I believe, 23 out of the 1,000 they found were assault weapons under California law. So I point this out to show that if these laws come into effect, they are subject to the same aggressive and arbitrary and capricious enforcement by law enforcement. We need to, those of us who don't live in the states that we know, that we in Texas commonly call the usual suspects, the California, Hawaii, Oregon, Maryland, Illinois, New York, New Jersey, Connecticut, you know the list. They call, you know, it's often said that the states are the laboratory of democracy. And I think that those of us who don't live in those states should make sure that that Frankenstein's monster never leaves those laboratories and in fact are returned to the grave.
The next discussion will be the dangers of universal background checks, red flag laws, and gun-free zones. John Lott will be speaking, and Tom Gresham is going to take over for me for the next two panels. So John Lott, we're running 5 minutes late, will be done at 5:30, and then Dave Harding will come on at 5:30 and be done by 5:45. We'll make up for 5 minutes. Thank you.
We are among superheroes. I don't know where we would be without the intellectual ammunition John Lott has been providing us for so long. He joins us right now talking about the dangers of universal background checks, red flag laws, and gun-free zones. Dr. John Lott.
I appreciate being here. I want to thank Julianne organizing this and putting things together as she has each year. So, oh, sorry about that. Okay. So I kind of want to talk a little bit about the current debate that's going on and tell you how I would kind of deal with the debate. So take something like universal background checks. I mean, obviously it's something that gets pushed after each mass public shooting. If you go back and look at when Obama was president, whenever we had a mass public shooting, it was usually the only law that he would go and try to push. The irony, obviously, is there's not one mass public shooting this century that would have been stopped by having that in effect. And I'm pretty skeptical that universal background checks, and I can talk about a little bit, would have any impact on crime rates. But people want to do something. I want to do something. If I want to do something, I try to do something like get rid of gun-free zones. But people who've been to these conferences in the past have heard me talk about it a lot. So if you're going to have universal background checks, and I have nothing in principle problem with it, I just don't think it's going to do any good, at least not have it do harm. And there's a few things which I consider very reasonable. One of the big phrases that's often used by gun control advocates is they want reasonable gun control laws. Well, let me advocate what I think are a few reasonable fixes for universal background checks, so I don't think they'll do harm. So one of the issues is costs. If you live in Washington, D.C., it costs $125 to go and do the universal background check to privately transfer a gun. You live in New York City, it costs at least that much. There are places which will charge even more. You go across the country, places like Oregon, you can find it for $55, what have you. But this is a real cost of going and doing it. It may not stop you or I from being able to get a gun, but my concern is that the people who benefit the most from owning guns, poor minorities, particularly poor blacks, $125 or even $80 may make the difference between whether they're able to obtain a gun legally to defend themselves and their families. But there's a bigger problem with this, and that is, let's say you really believe background checks lower crime. Well, do you really want to tax people for going and doing what you think is good? I mean, that's one thing I never really understand. It seems like you want to reward them rather than tax them. So if you really believe, if gun control advocates really believe that encouraging people to go and do background checks on the private transfers of guns will somehow reduce crime, why are you going to make them pay a $125 fee for doing that? You know, one of the more bizarre things, I'll just mention quickly, and that is, in Washington, D.C., if you and I lived there, and I was going to give you 4 guns to one person, you think that's just one background check, right? But no, the background checks are on each gun. So rather rather than charging $125, they charge $500 to transfer, and I think it gets to what the point is. So there's two issues here. One is, if you want to encourage background checks, don't penalize the person for going and doing it. And the second thing is, if you believe background checks reduce crime, you believe it reduces crime for everybody, not just the particularly law-abiding person who's going out of their way to go and do a background check. Well, if you believe that, if everybody benefits, then make everybody pay. Why put the entire burden of this on the law-abiding person who's going out of their way to go and have the background check on the private transfer there? Both of these arguments indicate that you should pay for this out of general revenue rather than putting the whole benefit on the person who you're supposedly wanting to encourage to go and do the background check. There's another issue here. That's this issue of false positives. And I understand the White House understands this, which is a huge step forward over previous administrations. So you constantly hear this claim that there are 3.5 million dangerous prohibited people that have been stopped from buying guns because of background checks. That's simply false, okay? Calling it a lie isn't too strong. Look, what you should say is that there are 3.5 million initial denials, and virtually all of those are mistakes. I can't tell you the exact number. I can give you a rough estimate. My own guess is it's something around 99% of the people who are stopped are mistakes. So you go and you look at the last annual report that was put out on the NICS system in 2010. The Obama administration stopped putting this out. They had 76,000 initial denials, and then there's 5 stages of review that occur in the NICS system. The first stage of review, the BATF National Office, no discretion, not having any lawyers looking at it, just have regular people going and just checking the paperwork. And about 94% of the cases are dropped at that stage. The second stage of review gets sent out to the BATF field offices. Again, no discretion, no lawyers looking at it, making sure the paperwork is right. They add a little bit about whether it's a recent case, but I found cases that deal with violations that are 45 years old, so I don't know what recent means in this case. And in 2004, Congress did an audit of the Brady Act on its 10th anniversary, and what they found is this second stage of review, there was another 2 percentage points of the cases that were dropped. So for just the first 2 stages of review, with no discretion, 96% of the cases that are dropped. If you look at the numbers for 2010, 76,000 initial denials, 48 cases were referred for prosecution, 28 cases were prosecuted, and they got 13 convictions. And if you look at the 13 convictions, particularly the ones that deal with things like perjury, so you fill out the form, you're a felon, you somehow forget to mention that on the form. And, these are actually easy convictions to go and get. And so the fact that there's so few convictions really makes you wonder. And there's a simple explanation for this, and that is they're not real cases. The irony is, when Clinton was president, Republicans attacked Clinton for not enforcing gun control laws. Exhibit A was all the background checks that were failed and a few number of convictions, exactly the types of numbers I'm going through. When Bush was president, Democrats attacked him for not enforcing the gun control laws. When Obama was president, Republicans, even some favorites of mine like Ted Cruz and whatever, would go and attack Obama for not enforcing the gun control laws. It's not that they're not enforcing the gun control laws. I have some good friends that were in the Bush administration. Reagan Dunn was the first director of Project Safe Neighborhood. That whole purpose of that group in the Department of Justice was to enforce gun control laws. And Reagan will tell you, he said, look, they'd love to prosecute the cases if they were real cases. But it's one thing to stop a felon from buying a gun. It's another thing to stop somebody simply because they have a similar name to a felon from buying a gun. When you fill out the 4473 forms, you put down your name, your social security number, your address, your age, your race, your eye color, your gender. You think they're using all that information? What they'll frequently use is just roughly, phonetically similar names and similar birthdays. And the problem is, it's particularly minorities that are harmed as a result of this. Hispanics and blacks. People tend to have names similar to others in their racial groups. Hispanics have names similar to other Hispanics. Blacks tend to have names similar to other blacks. 33% of black males are legally prohibited from owning guns because of past criminal history. Of course, there are other reasons why they may be prohibited too, but whose names are their names most likely to be confused with? Other law-abiding, good black males who want to get a gun to protect themselves and their families. Here's the deal. Go to a Democrat in Capitol Hill, and, because I've done this, and just say, don't talk to them about guns, but just say, you know, I think companies, when they do criminal background checks on employees, ought to just go and look at roughly phonetically similar names. They will have a count. I mean, they will go nuts on you, and they will say, well, there's absolutely no way you could do that. It's ridiculous. That would cause so many false positives, and it would be racially discriminatory. You say, you know, you're right on that. Of course, most companies, if you were to tell an employer, you know, maybe you ought to think about doing just roughly phonetically similar names. They're going to look like you're from Mars, because they have no desire to go and create all sorts of false positives for their employees. But why not, as a simple, quote, reasonable fix again, why not simply require that the federal government has to do criminal background checks in the same way that the federal government mandates that private companies have to do it? If it's good enough for the federal government to say you have to go and use the complete information that's there and use it exactly as it's presented to you, why isn't that good enough for the federal government? But look, I've been making these points to gun control advocates for 20 years now. And they will fight you. I'll give you one example. A few years ago, when Colorado was passing its background checks on private transfers of guns, I got a call from a few state legislators in Colorado asking me what amendments I would put up on the bill. And one of my suggestions was to put up an amendment that would exempt people below the poverty level from having to pay the new state tax that they have on transferring guns in Colorado. My understanding is the current governor has just increased this to like $75. So here's the deal. With the exception of 2 pro-gun Democrats in the state house, every other Democrat in the state house voted against exempting people below the poverty level from having to pay the new state tax. How many taxes can you think of that Democrats will fight tooth and nail against exempting people below the poverty level from having to pay? I mean, it's just ridiculous. It's those types of things, and I can give you multiple other stories that have convinced me over time they really don't care about getting this passed. What they care about are rules that make it costly for law-abiding citizens to be able to go and own guns. There's another issue with regard to background checks that could easily be fixed. So we have 2 problems that I've mentioned, 2 easy fixes so far. I think they're both reasonable. I don't even know how you argue against those types of things. So, just as an aside before I get into the other 2 things, my point would be, make the Democrats have to be defensive on this. Let them explain why it's okay to have a system that so massively discriminates against minorities. Make them explain why it's okay to you can appeal these cases when you have these false positives, but the vast majority of people are going to have to hire a lawyer. It can cost $3,000 plus to go and do that. You're basically discriminating against middle income and poor minorities overwhelmingly to do that. Make them explain why that's a reasonable system for somebody who, no fault of their own, is being stopped from being able to go and get a gun to protect themselves and their families. So one of the other big issues is that these universal background checks could be used fairly simply to create a national registry. And it would go something like this. Federally licensed dealers have to keep track of all the transfers and sales that they make under the universal background check system. They already have to do it for sales. Well, 5 years from now, you may have a new president and a new Congress that says, you know, all that information you've been collecting and you have to retain, we want you to package it and send it to the federal government. And then you're going to have kind of an instant national registration list for all law-abiding gun owners who have obtained a gun over the previous 5 years that are there. Well, there's a simple fix for this. And that is the same fix, again, that we can look to the federal government for. When the federal government goes and finishes a background check, under federal law, they are required within 24 hours to go and destroy that information. Well, simply have a time limit on how long the FFLs have to go and keep that information. We can debate, but you know, again, I think if you had that fixed, and I think it's a reasonable thing to make there, if they really care about the background check per se, you fix those three things, I have a hard time believing that there'd be much opposition at all. Now, I understand that President Trump has been thinking about having an app type system where it would be on a cell phone, and the seller would enter the information. You'd have to have a code from a notary republic to kind of keep me from going and finding out that Tom Grisham has 7 felonies from when he was young. You know, just typing in his name and finding that out. So, for privacy protection reasons. I think it's pretty neat. I'm sure the Democrats would go nuts over something like this for 2 reasons. One, it would effectively solve the cost issue that's there. And secondly, since all that information would be going through the federal government, and the federal government under current law has to destroy that information within 24 hours, it would effectively mean that you're not creating a national registration list for all those other states that are out there that don't currently require a background check on private transfers. Now, there's one other change to be made. If you read the laws that we have right now in terms of these universal background checks, one of the things they frequently have is that you're only allowed to transfer a gun to somebody temporarily under what's called, when they're in quote-unquote imminent danger. And for those who aren't lawyers in the room, imminent danger means they're right there facing the threat. You know, the attacker is like feet away and is threatening them right at that moment. Well, so you have a woman, a friend of yours, who you know knows how to use a gun and you know she has no criminal record, call you up late one evening and she tells you that an ex is threatening her, she's very afraid, the person's made threats, and she's